talk about strategic reading, which is a very important skill to have, especially because when you start law school, you don't really know what to look for when you're reading. So you're being thrown all of this information, so many cases, so many pages to read. So it's very common to lose a lot of time if you don't know where to look. So the challenge we're up against in law school is the complexity of the materials, right? The information. This is a new language that you're learning. The law is not a easy language. And then you have time constraints, right? Because we have a huge workload and we don't have just all of the time in the world, right? So keeping that in mind, what we do apply is what I call target-based reading. And it's based on this premise. If we start reading a case without knowing what we're looking for, chances are we'll get lost in irrelevant details or information that will distract us from the real important stuff. But if we know what we're looking for, we can identify those things faster and focus on the information that matters. So what we do is that we skim a case brief before you actually and carefully read the full case. So imagine we have to read Penaya versus Neff from Civ Pro, right? So if I click on here, it takes us to the full case, right? I mean, I don't have the book here. So this is a huge case, right? And it's a very old case. Look at this date right here. So, if you start reading this, probably you're going to get lost in a lot of in a lot of details that are not going to be relevant when, in terms of what your professor wants you to retain from this case. But if you go here and access a case brief of this case, then you're going to see exactly what's important in this case. If this decides to load. And this case brief that I'm getting, I got it from the internet. There are going to be cases that you're going to be able to find the case briefs on the internet, and other cases that you might just have to, either go on Quimby or ask at 3L for an outline. We'll talk about this in a minute because I do recommend that you do the 3L outline if you can. But let's get back to this. So here it is, right? Do you see the difference between reading this? Very simple, right? Okay, so here's the rule, the most important thing. This is the rule. This is a summary of the determinative facts, right? Because there are going to be facts that are not going to be relevant in the holding of the case. You have the issue, you have the answer, and the conclusion, right? So if you read this first and then you go back to the larger, the bigger case, you're going to know what to look for, right? You're going to be more attentive to what the rule is, what the issue is. So let's keep going. So the next steps, ask a 2L or 3L, probably 3L is better, who did really well and who has the same professor that you have for an outline. And specify that you want the longer version because sometimes people shrink the outline in order to be ready for exams. So make sure that you specify that. If that's not an option, you can either choose the internet or purchase Quimby. I know a lot of people who have done it and it works well. So that's, your choice. I personally use someone else's outline to skim case briefs because the outline is based on my professor's specific patterns and teachings and emphasis on certain points. So I sort of wanted that insight. A very important note. You might be tempted to solely rely on this outline or on this case brief as your reading tool, but don't do it unless it's an emergency because the real work is in carefully and fully reading each case, right? So this is where the comprehension happens. So, if you run out of time, obviously skim a case because we're human, we're perfect. You're probably not going to get to do all of the readings perfectly because life can happen. So in those moments, you can just skim the case and then go back to it after class and then read the full thing. But skimming case briefs is just an introductory tool or an emergency measure you use when you're running out of time for class. But generally, we use it as an introductory tool because it's going to guide us and it's going to tell us what to focus on. And that's what's going to be on the next mini training, which is step 2 of this process called strategic reading.
See you soon.
So let's keep going. Once you've skimmed the case and identified the important parts or gotten an idea on what the important parts would be, then we read the full case carefully, but we do it with our targets in mind. So the first target is going to be determinative facts. Those are facts that are relevant to the dispute. They answer the question of what happened that gave rise to this legal issue, to this case that we're reading about. And then we have the issue, which is okay, what is a conflict in this case? What is the question that the court is trying to solve and answer? Then we have the rule, which is the most important thing because we are going to be applying these rules that you learn through your cases on the actual exam. And the rule answers the question of what is the law, the rule, the set of rules, the task that they're applying to this specific facts. Then we have the reasoning that can also include the rational and policy. And this is asking how are they applying the specific rule, right? For example, are they applying a three-part test? How are they applying each part? And why? What's the rationale behind? Are they trying to advance some policy, some bigger purpose with this law? Are they trying to prevent something from happening? Or are they trying to incentivize something? Note that some professors are big on rationals and policy, so always take note on this when you're in class if they emphasize it, because adding a phrase on it on your exam will get you extra and bonus points. And finally, we have the holding. What is the end result? What is the legal conclusion in this dispute? It's important to be aware of the intention behind your reading and briefing. Are you reading and briefing in order to understand and comprehend the material, or are you reading and briefing in order to, you know, perform during a call? And why am I saying this? Because if we read with the intention to perform perfectly in front of everyone, we'll probably lose time memorizing or retaining details that don't necessarily matter. And that's an opportunity cost in law school because your time is going to be so limited. You could be spending, if you spend 1 hour in one case when you could have spent 30 minutes on another case, on another class, that is going to cost you time wise. So what we're going to do, what we have to do is differentiate between relevant details versus irrelevant details so that we can discard the irrelevant details and retain the information that really matters. Some examples of irrelevant details could be exact names of parties, exact name of a little city, a date when whatever happened is not determinative legally speaking. So we have a negligence case and there's a doctor who injured some patient. We're probably going to be focusing on the procedure rather than on what day happened and the name of the hospital where it happened, right? Versus if we have a breach of contract, which, something had to be delivered by a certain date and it wasn't, then yes, the day would be determinative. So you'll be able to see what details are relevant or not, especially if you skim the case brief first. And also other irrelevant information that it's not going to serve you for your outline or exam purposes. It is true, however, that in Civ Pro, as you approach personal jurisdiction and diversity jurisdiction, which you don't have to worry about right now, you'll notice that you'll be retaining more facts because you'll probably use them in analogies, but that's something that comes later, so don't worry about that. And now we're going to talk a little bit about cold calling and reading. I just want to make a quick note on this, so please watch the next video. Mwah.